The Honourable Adam Searle.
Thank you, Mr Deputy President. I lead for the opposition in debate on the Crimes Amendment Publicly Threatening and Inciting Violence Bill 2018. The opposition will not be opposing the bill, but we note that the government's performance on this issue has been nothing short of abysmal. This bill contains provisions that we, on this side of the House and in the other place, have advocated for many years. Many of the elements of the 2016 Private Members Bill, voted down by the government in the other place by 48 votes to 31, put forward by the Shadow Attorney-General, are contained in this very bill before the House this evening. The bill contains many of the elements for which notice was given earlier in the year by the Leader of the Opposition in the other place. The provisions of Section 20 D of the Anti-Discrimination Act impose criminal liability for the act of racial vilification. Despite egregious examples of what most would agree was serious racial vilification, there have been no prosecutions. In November 2012, then Premier O'Farrell referred the issue to the Legislative Council Standing Committee on Law and Justice. In a report dated December 2013 entitled Racial Vilification in New South Wales, the committee made unanimous and cross-party recommendations. The government has been stuck there for years. Self-evidently, it's taken this government 5 years to produce a bill that contains many of the recommendations in that report. And during that same elapse of time, the government and its members in each House, well, in the other place, voted down private members' bills put forward by the opposition which contained many of the committee recommendations. The delay of 5 years is extraordinary. The government's own committee members pointed the way in 2013. It's not as if the government did not know what needed to be done in this area, or indeed how to do it. In 2015, the then Attorney-General, Upton, conceded that the laws in this area were broken. She promised to introduce new laws in the first half of 2016, but she did not. In late 2016, the government commenced yet another consultation process, this time with Stephen Kirkasharian. Stakeholders were told with great excitement that amendments would be introduced to Section 20 D in mid-2017. But that did not happen either, Mr Deputy President. At the end of last year, media reports exposed that the government had decided to take no action and highlighted serious divisions within the Cabinet, with ministers, including the Treasurer, Mr Perrottet, and Ministers Roberts, Elliott and Upton opposing any change. They rolled the now Attorney. Their approach no doubt echoed the comments in 2016 by the member for Epping in the other place during the second reading debate on the Shadow Attorney's bill. He said that the bill was opposed by him on free speech grounds, just as he did the recent safe access zones legislation, Mr Deputy President. The ministers voting with him on that latter legislation are those identified by the media as opposing the essential elements of this bill in Cabinet at that earlier time. The core of this bill is to insert into the Crimes Act a new 93 Z. In summary, this provision will create a new criminal offence of publicly threatening or inciting violence on the grounds of race, religion, sexual orientation, gender identity, intersex or HIV/AIDS status. A number of things are done in creating this offence. Most obviously, it's a provision of the Crimes Act rather than the Anti-Discrimination Act. These are crimes, and it is symbolically important to have the offence in the Crimes Act, particularly given the lack of action taken to enforce it previously. Schedule 2 makes it clear there is no need for a referral by the President of the Anti-Discrimination Board to the Director of Public Prosecutions for prosecution, and the incidents can be investigated by police as crimes. In practical terms, Mr Deputy President, this is quite significant. The people best able to investigate crimes, to prepare statements in admissible form, to prepare statements that allow prosecutions are police rather than, for example, officers of the Anti-Discrimination Board. That is the job that the police do each day. I note in passing that this practical difficulty and issues surrounding briefs prepared by non-police do have echoes of the situation of the Independent Commission Against Corruption submitting briefs to the DPP for possible prosecution. Proposed Section 93Z replaces currently existing offences. Their replacement is affected by Schedule 2 to the bill. The offences of serious racial vilification under Section 20 capital D of the Anti-Discrimination Act, serious transgender vilification under 38T of that Act, serious homosexual vilification under Section 49 capital ZTA, and serious HIV/AIDS vilification under Section 49ZXC are all removed. Schedule 2 also has the amendments to the Anti-Discrimination Act to no longer require investigation by the Anti-Discrimination Board for prosecutions to occur. Proposed Section 93Z gathers together all these vilification provisions into one section rather than having them spread over various portions of legislation, which of course reflects the historical evolution of the vilification provisions in the Anti-Discrimination Act. While Section 20D has not resulted in successful prosecutions, or indeed, as far as I'm aware, any prosecutions, other of the vilification provisions have. It would be entirely inappropriate to make amendments only to 20D and not to the other provisions, as they are all based on the same legislative template and all are forms of vilification which ought to be properly criminalised. There are several differences between the proposed 93Z and the previous provision. The terms homosexual and transgendered are replaced with the more modern parlance of sexual orientation and gender identity. Another positive difference is that the current protections are extended to intersex status. That seems entirely uncontroversial on this side of the House. The protections are extended to include religious belief or affiliation, but not define a religion, and that extension is welcomed by the Labor opposition. Earlier this year, the Leader of the Opposition in the other place gave notice of a bill that contained that provision and remains on the business paper. Historically, there are some traditional concerns about including religion in anti-discrimination legislation, especially in New South Wales. Race was included as a protected attribute in the anti-discrimination legislation and was defined to include, in Section 4, ethno-religious origins. In a second reading debate, that phrase was said to include Judaism, Sikhism and Islam, but that is not what courts and tribunals have subsequently held it to mean. Opposition to extending religion as a protected attribute is usually based upon one of two grounds. One is that it's close to a blasphemy law, which is regarded as inappropriate in a modern liberal democratic society. Nearly 250 years after the death of Voltaire, we agree on this side of the House, blasphemy laws should have no place in this state. There are, of course, several problems with that argument. The first is that those who pursue it have done nothing to remove the blasphemy offence, which is exclusively of Christian religions, from the law of this state. Section 574 of the Crimes Act maintains it is still a criminal offence in this state to scoff at the Christian religion, although not at any other religion. Secondly, the bill has nothing to do with blasphemy or being critical of religion. It's directly and inextricably linked to violence, incitement to violence or threats of violence. People who oppose this provision due to a fear of blasphemy or a fear of freedom of speech simply haven't read the legislation or understood it and cannot seem to distinguish this from the 18 capital C debate in federal politics. The second potential criticism is that religion can be notoriously difficult to define. Will it include, for example, Wicca, white witches, or perhaps Jedi Knights? That is a legitimate argument, in part because some of these bodies have turned up from time to time in the census. But we're not troubled by it in relation to this bill, because this bill is connected very explicitly with violence, incitement to violence, or threats of violence, and surely we should all join in supporting measures directed to ending violence wherever it may occur. If it were a more general anti-discrimination issue, then maybe that would be a legitimate point, but it seems that there is no argument against the provisions of this bill because it is directed at ending violence. Proposed Section 93Z makes clear that recklessness can constitute sufficient criminal intent for prosecution. That has been a live issue discussed for some time. It was recommended by the Legislative Council Committee and included in the Shadow Attorney's 2016 bill. It's included in this bill and ought to be. Proposed section 93Z2 deals with what is sometimes called the presumed race issue. If a person is the subject of racial vilification because the perpetrator believes and says, for example, that the victim is Japanese, when in fact they are Chinese, a prosecution under the current provisions may fail. Resolving this was also a Legislative Council committee recommendation and a provision of the opposition's bill. Once again, that is in this bill and should be. Proposed section 93Z4 provides that prior prosecution should only be commenced with the approval of the Director of Public Prosecutions. This is a change to the current position, which requires the consent of the Attorney-General. The Legislative Council Committee report recommended removing the provision for consent of the Attorney-General. That is a position with which the opposition agrees. The committee adopted that view because the committee thought it would perhaps politicise the decision-making process. The provision of the requirement for the attorney's consent stems from an earlier time when the attorney was seen to be above the political fray compared to other ministers and had a greater degree of independence.
Here, that's Mr. Speakman entirely.
I suspect that the current attorney might like to go back to those days, but at least for the foreseeable future, those times are probably long gone. Well, it is a shame. The requirement for the attorney's consent was seen as a safeguard on overzealous or injudicious prosecutions. The perception of the attorney's role has, I think, changed significantly, perhaps for the worse, but nonetheless it has changed. There are still provisions requiring the attorney's consent for prosecution, for example, in proposed section 316 and proposed section 316 capital A of the Crimes Act. But it seems a little odd that those provisions concerning the attorney remain, especially as we understand it, when the attorney has to all practical intents and purposes delegated his decision-making powers to the DPP in any case. One of the other ongoing debates is the private versus public publication issue. The general public policy objective has been to criminalise public action, but not necessarily private ones. That inevitably gives rise to disputes about what is considered private and what is considered public. This bill includes any form of communication available to the public that includes social media and other electronic methods. It also includes any conduct observable by the public. For more abundant caution, it can be a public act, even if occurring on private land. That seems like a reasonably good place to start to get this definitional issue right. The precise offence proposed in 93Z is of threatening or inciting violence towards another person or group on the basis of the protected attributes. Incite is the term currently in the provision of section 20 capital D. The Labor opposition had proposed to lower the bar for prosecution by replacing this with the term promote. There was discussion, of course, about this in the Legislative Council report. The bill provides as an alternative basis for the offence to threaten violence. 20D1A has a reference to threatening already, albeit in a differently structured offence. The current maximum penalties for section 20D offences are 50 penalty units or 6 months imprisonment or both for an individual and 100 penalty units for a corporation. That is the same as the penalty for section 49ZXC. Section 38T has 10 penalty units or 6 months imprisonment or both for an individual and 100 penalty units for a corporation, as does section 49ZTA. Proposed section 93Z provides a maximum penalty of 100 penalty units or 3 years imprisonment or both for an individual or 500 penalty units for a corporation. This makes proposed section 93Z an indictable offence to be dealt with by a judge. However, Schedule 3 to the bill amends the Criminal Procedure Act so that the proposed section 93Z is inserted into Table 1 of that Act, meaning it may be dealt with summarily unless the prosecution or person charged elects otherwise. As I indicated, given that the opposition has advocated for so many of the provisions in this bill for such a long period of time, it can surprise nobody that the opposition will not oppose the bill. It's taken the government 5 years too long, and it's so outrageous that it has taken that long, but I guess those opposite might say better late than never.
Now, just before I call